Parviz Jarabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, 4 10-hour shifts rule in California, part 1. California labor laws allow for 4-hour shifts or an alternative work week schedule that require you to work up to 10 hours in a day. The alternative work week schedule is a different way to structure your work week than the normal 8-hour day. Under this schedule, you work up to 10 hours in a 24-hour period, which is over 8 hours per day, but work fewer days in the work week. Some common alternative work week schedules used in California workplaces include a 4-day work week at 10 hours per day, known as a 4/10 work week, or 3 days of 10 hours and 2 days of 5 hours, or 8 days of 9 hours, 1 day of 8 hours, and an extra day off in a 2-week period known as a 9/80 schedule, because it spaces the 80 hours over only 9 days instead of 10 days. In California, you can decide to use an alternative work week schedule by voting, and once the schedule is validly adopted through a clearly defined legal process. The process includes the following steps that must be followed. First, your employer must propose an alternative work week schedule in writing or through a collective bargaining agreement. When your employer proposes an alternative work week schedule, it can offer a single alternative work week schedule or a menu of options. One of these options could be a standard schedule of 8 hours daily. Your employer must issue a written disclosure that details the proposed schedule and hold a meeting at least 14 days prior to voting. If more than 5% of the affected employees speak a language other than English, the written disclosure must be provided in that language as well. Employers can advocate for or against an alternative work week schedule, but cannot intimidate, discriminate against, retaliate against, or terminate you over the election or the alternative work week schedule. Next, to decide whether to adopt an alternative work week schedule, the election must be held on the work side of the affected employees during regular working hours. It must be a secret ballot election and happen before the new schedule is implemented. To pass, at least 2/3 of the vote of the affected employees in the work units must support the alternative schedule. If approved by 2/3 vote, California employers have to report the result of the election to the Division of the Labor Standards Enforcement at the Department of Industrial Relations within 30 days. If you and your fellow employees adopt a menu of work schedule options, you can switch from one schedule to another on a weekly basis with your employer's consent. Your employers cannot reduce your regular rate of pay regardless of whether you and your fellow workers vote to approve, deny, or revoke an alternative work week schedule in the secret ballot vote. Regardless of which schedule you select, the payments of overtime must be made to you no later than payday for the next regular pay period. Remember, your rights as an employee are protected by law, and you have the means to take action if your employer fails to comply with the regulations. So stay informed, know your rights, and advocate for the fair treatment in the workplace. If you have any question on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.